Police Minister's decision to suspend Ipid head Robert McBride was invalid. Confirming a High Court order, the Constitutional Court said Nathi Nhleko did not have the powers to act against McBride. Nhleko says he is studying the implications, but the Democratic Alliance wants him to resign immediately. What does this imply for McBride and Nhleko as well as the Parliament going forward? Well, Michael Apple reports.
Walking out of the Constitutional Court, suspended Independent Police Investigative Directorate head Robert McBride was a relieved man.
To say we're happy with the judgment, and as soon as the 30 days are over, we'd like to get back to work and start stabilizing the Independent Police Investigative Directorate. Also, I think it's important, there's a lesson that's learned, especially for the executive and in particular the minister, that how not to govern, how not to interfere with the independent organization. So I hope there's lessons learned about constitutionality in certain sectors of the executive.
The court has set aside Police Minister Nathi Nhleko's decision to suspend and take disciplinary action against McBride.
It is declared that the decision of the Minister of Police to suspend Mr. Robert McBride from his position as Executive Director of the Independent Police Investigative Directorate is invalid and is set aside. It is declared that the decision of the Minister of Police to institute the disciplinary inquiry against Mr. Robert McBride, which was to commence on 21 May 2015, is invalid and is set aside.
While the Constitutional Court judgment vindicated McBride, one hurdle remains. Parliament or the Police Minister have 30 days within which to consider bringing fresh disciplinary action against McBride.
If Parliament wishes to do this, it will be astonishing. Parliament is already, in the eyes of so many, an utterly discredited institution. If they want to go this route, well, then they must go, but we'll be watching them as well.
Parliament now has the task of, within 24 months, to amend and remedy many of the provisions the Constitutional Court found to be invalid. Meanwhile, the Police Ministry says it has noted the judgment, but says that the Constitutional Court ruling in no way affects the validity of the charges McBride faced. So the decision then to institute disciplinary proceedings against Ipid head Robert McBride, as well as suspend him, have been set aside. It's all eyes then on Police Minister Nathi Nhleko in particular and Parliament to see whether they decide to implement fresh disciplinary proceedings within the 30 days given by the Constitutional Court. Michael Apple, ANN7, Constitutional Court, Johannesburg.
Well, joining us on the phone line now is Mr. Zahir Omar. He is a legal expert. He will be giving us his insight with regards to this matter. Mr. Omar, thank you for joining us. A huge vindication there for Robert McBride and the Ipid as an institution as well. Can we expect him to be reinstated soon after this, or is it just not that simple? Can we expect further legal hurdles at this point?
Look, what the Constitutional Court did today was to find that Ipid is an independent institution, more specifically independent of the Minister of Police. The Constitutional Court found provisions in the Ipid Act, Public Services Act, to be unconstitutional. That simply means that the Minister of Police did not have the power or the jurisdiction to suspend Robert McBride, firstly. The Constitutional Court sent the matter back to Parliament. Ipid is the watchdog of the police. So if a member of the public have a complaint against a policeman, then that member of the public will complain to Ipid. The position now is as follows. Robert McBride has not been exonerated of the accusations against him. Robert McBride was accused of altering documents that implicated Anwar Dramat and General Sibaya for unlawfully having deported people to Zimbabwe. Now, unlawful deportation is not a crime per se. What is striking is that Robert McBride was suspended from highest office of Ipid, whereas Ronnie Caswell, the former Minister of Intelligence, including the president, the former President Mbeki, and his whole cabinet were not sanctioned, despite the Supreme Court of Appeals having found them to have been guilty of unlawfully having orchestrated the unlawful deportation of Khalid Rashid from our country. And another issue that we must pay attention to is the word rendition. There is no such thing as rendition. If rendition is intended to mean enforced disappearance, then it is a crime against humanity in terms of the Rome Statute. Robert McBride can still be pursued, but the only way he could be pursued is that if he is criminally charged for abduction or kidnapping. But he did not commit any crime. The Constitutional Court did not make a finding on the merits. This is not egg in the face of anyone. Any suggestion that there's egg in the face of Parliament or the Minister of Police is wrong. This is a sign of a transparent democracy with an enormous growth of our constitutional law. Our Constitution is a young document, and what our Constitutional Court is doing is breathing life into our Constitution. And this is all being done through the transparent governance of the President Zuma administration.
Right, Mr. Omar, just very quickly, you mentioned the Parliament there. We do know that it has been given 2 years to amend the provisions that have been declared as invalid. What are the options before Parliament right now? Of course, in terms of disciplinary action against McBride and as well as the amendment of the law itself.
Look, the position is as follows. If the Minister of Police does not have jurisdiction over the head of Ipid, who does? The question then is, if there are allegations of impropriety against the head of Ipid, who has the jurisdiction to sanction members of Ipid? This is what Parliament will have to reconsider. So Parliament will have to make legislation that is not unconstitutional, that would give someone the jurisdiction to sanction the head of Ipid. But having regard to the accusations against Comrade McBride, if there is any truth in it, then Comrade McBride can easily be charged for being complicit in the crime of abduction. But that has to date not been done. That means then that there is insufficient facts to link Comrade McBride to the commission of any crime. So whatever must happen now should come to a dead stop. The Parliament must investigate ways of amending the law so that, or to adjust the law so that there could be someone to whom Ipid is subservient. All other police officers acting under the Police Act are subservient to the jurisdiction of the Minister of Police. But Ipid, the Constitutional Court found, is an independent body, and this is what Parliament will have to investigate. And the reason 2 years is given to Parliament is because the process is long. It's not unusual in any democracy in the world. Parliament will have to will have to take time and take measures to ensure the proper legislation is enacted to have even the head of Ipid be subject to the jurisdiction of someone.
Right. So what we have understood today from the Constitutional Court is they have drawn the lines when it comes to separation of powers between the police ministry and Ipid. Going forward, how do you think this judgment will impact the police minister's powers?
No. Comrade Nhleko, the Minister of Police, did nothing wrong. In fact, he should be applauded. He should be applauded in contributing to the growth of understanding of our Constitution. You'll remember recently when the Constitutional Court found that the National Assembly were wrong in their interpretation of the powers of the Public Protector. I myself interpreted the Constitution to mean that the Public Protector is subservient to the National Assembly. And this is how President Zuma was advised. This is what the legal experts told the National Assembly. But the Constitutional Court found otherwise. This is understandable. Our Constitution is young. In fact, today's judgment from the Constitutional Court is the very first judgment in the history of our young democracy on the provisions of Section 206, subsection 6 of the Constitution. People who are suggesting that Parliament have egg in their face, or Minister Nathi Nhleko has egg on his face, are being mischievous. And these are not being patriotic South Africans. We are only 22 years in our young South Africa, in our young democracy, and we need the Constitutional Court to breathe meaning into provisions of the Constitution which remain uncertain. Today's is the very first case in the history of our country on the interpretation and the application of Section 206, subsection 6 of our Constitution. This will give Parliament guidance. It would give our government guidance of how to apply the provisions of our Constitution.
Right, Mr. Omar, thank you so much for your insight and on your time here on ANN7. So our political analyst there, Mr. Omar, just making it very clear what the Concourt's ruling was about today, that assertions from the police ministry that the IPID head should be suspended were unconstitutional and that any other charges against Mr. McBride could still be reinstated.